Good morning. It's my great pleasure to welcome you to the University of Georgia School of Law and to our conference, Who Are They to Judge? Ethical and Professionalism Issues Facing the Bench. It's also a pleasure to see so many of our alums here. That's just wonderful to have you come back to our law school. Through the years, there has been considerable discussion about civility among members of the bar, with many lamenting the loss of civility, professional courtesy, and collegiality that were once, or so we hear, commonplace in the legal profession. But today's discussion focuses not on lawyers, but on those who judge their lapses. Are our judges, state and federal, modeling the civility and professionalism that we believe lawyers should display? How do we select our judges? And does that selection process influence behavior once a judge is on the bench? And how do we best identify and handle judicial misconduct when it occurs? We have a stellar lineup of speakers to lead this discussion, and I am grateful to each of you for being here. A very special thank you to Judge David Sentelle and Chief Justice Marcia Turnus for delivering our featured addresses. We appreciate greatly your sharing your time and your thoughts with us. Thank you so much for being here. I also want to add my thanks to my colleague, Associate Dean Lonnie Brown, the A. Gus Cleveland Chair of Legal Ethics and Professionalism, for imagining and organizing this conference. Events such as today's conference are essential in the creation of an outstanding academic atmosphere for our students, while also providing a valuable service to lawyers and judges who confront and grapple with these difficult issues in the practice of law. So Lonnie, please know how much I and the law school appreciate what you have done to make this conference a reality. Thank you. I hope that each of you will have a chance while you're here to look around our law school. For those of you who have graduated from here and have not been back in a while, it probably looks a little different than it did the last time you visited, so we're glad that you'll have that opportunity to take a look. This is a special place, one with outstanding students and dedicated faculty, and we're glad to have this opportunity to host you. I'll turn the program now over to Dean Brown, who will give you an overview of today's events, so please join me in welcoming Associate Dean Lonnie Brown.
It's also my pleasure to welcome you to the 14th Annual Legal Ethics and Professionalism Symposium. As many of you may know, this annual event, which rotates among the 4 Georgia law schools, besides us, Mercer, Georgia State, and Emory, is made possible through an endowment created pursuant to a consent decree entered by the Honorable Hugh Lawson of the U.S. District Court for the Middle District of Georgia. The decree settled allegations of litigation misconduct in exchange for a substantial financial contribution that helps fund these annual symposia, as well as academic chairs at each of the Georgia law schools dedicated to ethics and professionalism. We're all very thankful for Judge Lawson's and the party's creative resolution of that case. And I'm happy to say that Judge Lawson is here with us, and I ask that he stand to be recognized. In the past, the respective Georgia law schools have addressed a wide variety of topics important to the legal profession, such as ethics and settlement negotiations, problems in discovery and professionalism, teaching ethics and professionalism, taking your case to the court of public opinion, drawing the ethical line, controversial cases, zealous advocacy, and the public good, and most recently, defining and enforcing the federal prosecutor's duty to disclose exculpatory evidence. This year, we've decided to focus on judicial ethics and professionalism and the interplay between the bench and the bar in these 2 areas. The inspiration for this topic came from the growing number of judicial discipline cases that were cropping up in Georgia and across the country, with such eye-catching headlines as "Intemperate Family Court Judge Suspended for Angry Rant Caught on YouTube," "Michigan Justice Announces Retirement After Accusation of Blatant and Brazen Misconduct," "Judge Removed from Divorce Case After Sending One Party a Facebook Friend Request," and my personal favorite, "Shirtless Judge Suspended." Such headlines are certainly not representative of the vast majority of the judiciary, but they do raise legitimate concerns about some of those to whom we have entrusted the precious scales of justice. Who are they to judge? And how did they end up in the position to judge? I asked my 13-year-old daughter what was the first word that came to her mind when she thought of a judge. And to my shock and surprise, she responded with the word biased. Because she's very perceptive and smart, my guess is that this view of judges stems from the public information regarding the judiciary that we are now routinely subjected to, much of which is unflattering. The good stuff isn't typically reported or talked about. Besides the headlines about misconduct, during campaign season, we hear and see judicial pronouncements that are shocking in their incivility and casual regard for the truth. Take, for example, this excerpt from a state Supreme Court campaign speech. Quote, Justice Sheila McCarthy has voted to reverse more murder convictions than any member of the court. Her opinions are filled with legalistic nitpickings that warm the soul of every criminal defense lawyer in the state. The ACLU loves her. Her opinions drip with sympathy for these murderers. They give hope to the thugs on death row. It's time, ladies and gentlemen, to take away her robe, her pen, her vote, her power to trample the rights of victims. End quote. Outrageous, right? Cringeworthy. It's not real. I must confess, this was not taken from a real-life campaign speech, but it could have been. This quote is from John Grisham's novel, The Appeal, which tellingly focuses on a campaign orchestrated by a corporate litigant with the goal of ridding the Mississippi Supreme Court of a justice who was sure to rule against the company in a high-stakes products liability case. As evidence that truth truly is stranger than, or at least as strange as fiction, one of our speakers, Chief Justice Marsha Turnus, was the victim of a very similar campaign strategy, which we will hear about later. No wonder my daughter thinks judges are biased. The fact that she does, however, troubles me greatly, because I still hold on to the judicial ideal. I think that judges should be viewed as residing on the highest legal plane. As the preamble to the ABA Model Code of Judicial Conduct provides, quote, the judiciary plays a central role in preserving the principles of justice and the rule of law. Inherent in all the judicial conduct rules are the precepts that judges individually and collectively must respect and honor judicial office as a public trust and strive to maintain and enhance confidence in the legal system. Judges should maintain the dignity of judicial office at all times and avoid both impropriety and the appearance of impropriety in their professional and personal lives. They should aspire at all times to conduct that ensures the greatest public confidence in their independence, impartiality, integrity, and competence. Close quote. To me, that embodies what it means to be a judge. With great power comes great responsibility, and the public has every right to expect our judges to strive at all times for the ideal. Over the next several hours, our assembled experts are going to explore this ideal and ponder whether judges can realistically be expected to live up to it in light of the modern challenges that accompany a seat on the bench. In particular, our distinguished presenters will examine three principal areas. 1, collegiality, decorum, and civility. 2, judicial elections and their effect on the decision-making process. And 3, the mechanics of the judicial disciplinary process and new obstacles to behaving ethically. I hope that you find the program to be engaging and educational, and I urge you to actively participate at appropriate times. I know that we have a wealth of knowledge and experience in the audience, and so please be generous in sharing that with us. In terms of format, I think the program is pretty self-explanatory and will be pretty much self-executing. My primary responsibilities throughout the day, in addition to moderating the first panel, will be simply to make introductions and to ensure that we are kept on schedule. And with that in mind, I will now seamlessly move to the introduction of our first featured speaker, the Honorable David B. Sentelle, who will address the topic of collegiality and decorum on the bench. Judge Sentelle is a senior judge on what is widely considered to be the most influential court in the country, the U.S. Court of Appeals for the D.C. Circuit. He was appointed by President Reagan in 1987 to fill Justice Antonin Scalia's vacated seat and served as Chief Judge of the court from 2008 to 2013. While on the Court of Appeals, Judge Sentelle has also served as the chairman of the United States Judicial Conference's Executive Committee and the Committee on Judicial Security. Before ascending to the D.C. Circuit, Judge Sentelle was an assistant U.S. attorney in Charlotte, North Carolina, served as a North Carolina State District Court judge, practiced law as a partner with the firm of Tucker, Hicks, Sentelle, Moon, and Hodge, and in 1985 was appointed U.S. District Court judge for the Western District of North Carolina. It is most fitting that Judge Sentelle will be speaking to us today about judicial collegiality and decorum. The D.C. Circuit, notwithstanding the divergent political and social views reflected amongst its judges, is consistently regarded as one of our nation's most collegial and professional courts. On the occasion of the portrait hanging of Judge Sentelle, his colleague, Judge David Tatel, a Clinton appointee, delivered the following remarks, quote, "Those who believe judges' decisions are driven by ideology may wonder why Judge Sentelle asked me to speak. After all, you'd be hard-pressed to find two judges with more different backgrounds, different worldviews, different beliefs, and indeed different shoes than we two Davids. But those who focus on these differences do not understand what it means to be a federal judge, do not understand this court's long tradition of collegiality, and surely do not understand Dave Sentelle. Flipping through his opinions, including dissents, you'll find no sarcasm, no belittling remarks, no callous dismissals. This is, after all, a United States court, and Judge Sentelle's opinions are a credit to the dignity of this institution. In his 5 years as Chief Judge, he has protected our proudly nurtured tradition of collegiality, navigating sometimes sensitive waters with a firm but gentle oar." End quote. Judge Tatel concluded, as will I, with this, quote, "We are grateful for your quarter century of exemplary service, and I can only hope that all those who look upon your portrait in the years to come see the man we do, a man who has the greatest respect for the office he holds and abiding dedication to a life of service and the rule of law." Close quote. It is my honor and privilege to present to you Judge David Sentelle.
Thank you, Dean. I don't know that I live up to everything that either you or David Tatel said, but it's nice to hear it, and maybe somebody will believe it. I did not, in the original understanding of what I'm doing today, focus on collegiality, though I will mention it in passing. I'm speaking more today on judicial civility. I want to thank the University of Georgia Law School for giving me the opportunity to be here today. I do think when you work in Washington, D.C., you should visit the United States occasionally. I'm going to preface my remarks by saying that this subject of judicial civility is not a subject which lends itself well to scholarly interpretation. It's more attuned to personal reflection, anecdotal recollection, and although this is a state institution, there will be occasional references to religion. And I hasten to say that the religious references are going to reflect on moral codes and not on theology. Now, with reference to scholarly material on the subject, I do recommend the short article by Professor Peter Joy, A Professionalism Creed for Judges, Leading by Example, in 52 SCL Rev 667, and Judge Marvin Aspen's article, Search for Renewed Civility in Litigation, 28 Val UL Rev 513, 1994. You also have in the material, not thanks to me, but thanks to someone else, the civility article of my colleague Harry Edwards, which reflects Harry's, I would have to admit, restoration of civility to our court, which had not always been as civil and as collegial in the past. We were civil, I think, but not collegial in the past as it became during Harry's tenure, and as I and as Judge Ginsburg and I and now Merrick Garland have tried to maintain. But before even undertaking what I will concede is a rather rambling personal reflection on the subject of judicial civility, I will first confront the question of why was I chosen to address this subject. I thought perhaps I was chosen as a horrible example. Reflecting on over 30 years of being on one bench and another, of 3 years as a state trial judge and 2 as a district court judge and over 26 on the circuit, I think I've committed most of the wrongs against which I would admonish others. But that brings me to my first reference to religion. I grew up as an evangelical Christian and had occasion to reflect on the characteristics of a good evangelist, since we went to the evangelist meetings a week or so every summer. And I came to the conclusion in my youth that the best evangelist was one who had sinned enough to have repented enough to caution others, do as I say, not as I have done. And so that's what I will be doing today. So if you happen upon attorneys who tell you that they appeared before me and I was an uncivil jackass, they may be right. I've not lived up always to the aspirations that I expressed today. That doesn't mean that I'm speaking anything other than the truth, and the truth does not care who tells it. That said, it's altogether appropriate that we reflect as a group on the civility, as a profession, on the civility of and from the bench. The civility of the bar has been a subject of appropriate concern for decades. In 1977, then Chief Justice Warren Burger, accompanied by other American lawyers and jurists, spent 2 weeks in Britain as a part of an Anglo-American law exchange. After reflecting on the collegiality and civility of the English Inns of Court, Burger, who was conspicuously assisted by Ninth Circuit Judge Cliff Wallace and United States District Judge Sherman Christensen of the District of Utah, conceived of an organization which came to be called the American Inns of Court, which they and others, including Professor Sherman Cohen of Georgetown and former Solicitor General Rex Lee, founded as a vehicle for the advancement and retention from generation to generation of patterns of professionalism, ethics, and civility for American jurists, lawyers, and judges. The American Bar Association and other professional groups have likewise aspired for these same goals. Its aspiration is not only appropriate, but of the highest importance. The bar and the bench stand near the top in responsibility for an ethical and civil society. I do not need to tell you that we do not live in a universally civil society today. Justice Clarence Thomas pointed out in a speech to the American Inns of Court National Meeting that you only need to go to the grocery store to find out, as people push their carts in lines ahead of you carrying 17 items in a 15-line and grace you with the dirtiest of looks if you clear your throat. If you drive home in a congested area at the end of the business day, you no longer have to be in New York metropolitan area to hear the horns of people sitting behind you, blowing their horns at drivers who would certainly move if they could. I do not suggest that the American people are altogether uncivil. I do suggest that uncivil behavior is widespread and conspicuous. Well, why do the bench and the bar have a particular obligation to the restoration of civility? For many reasons, perhaps, but as succinctly as I've been able to conceive it, we are the profession that more than any other represents the rule of law and order. A civil society is an orderly society. It is a society in which members respect the needs and goals of fellow members. Within the current society, lawyers constitute a privileged class. Lawyers practice their profession with legally protected oligopoly. Society, acting through the states, licenses the attorneys. If you don't have that license, you can't practice the legal profession. In return for that perfection, lawyers have the obligation to do it right. And I'll come back to judges in a moment. I'm starting with the lawyers. The lawyers exercise unique professional rights. They protect the rights of others, but they also assert the rights of others. Lawyers have the unique license to approach the organs of government coercion, the courts and the agencies, on behalf of persons who are making claims against others. For the profession to have effect, the law must be obeyed and order must be maintained. Otherwise, the declamations of the attorneys and the pleas on behalf of their clients are become a sounding brass or tinkling cymbal, and the old disorder pre-civilization disorder in which might made right displaces the established order of the rule of law. It is accepted wisdom that justice must not only be done, it must be seen to be done, and if lawyers, in the avowed pursuit of the legitimate interest of their clients, cannot behave civilly to each other, then they set a poor example to that society which has granted them protective license. And let there be no mistake, lawyers are examples. We have become accustomed to hearing professional athletes declaring that they do not want to be role models. Nonetheless, to the youth that follow the practice of their trade, they are role models. The same is true of the bar. If the citizens whom you represent do not see obedience to the norms of civility and order in those who are professionally pursuing those norms, then it is unfair to expect better of them. Shakespeare had some things to say about lawyers, and the most famous one, of course, is the one that's always quoted out of context that proposes to kill all the lawyers, but that's not the one I'm talking about today. The pertinent one today comes from The Taming of the Shrew, Act 1, Scene 2, where Tranio, in the disguise of Lucentio, admonishes the suitors of Bianca, "Do as adversaries do in law, strive mightily, but eat and drink as friends." And despite the oddity of that context, Shakespeare accepted as given truth that English barristers could strive mightily while maintaining the civility displayed to this day in the British Inns of Court, to which the barristers could repair for refreshment and conviviality. That, I suggest, is the example that the bar should strive to set in America today. But I promised I would get back to judges. Most of the discussion of civility sponsored by judges and the American organizations concerns the behavior of the bar, not our own behavior. We judges are quite ready to wax eloquent in condemnation of Rambo lawyers, and we should be. We lament that the civility and friendships lauded by Shakespeare and displayed in the ancient British Inns of Court has been perhaps not lost, but at least dramatically weakened in the American bar. And we're right to do so. When litigants, officials, criminal defendants, witnesses, and victims see attorneys behaving like uncivil barbarians in the very temples of law and order, we can hardly expect them to display better behavior than the examples that the lawyers set. The lawyers, after all, are near the top of the profession, and yet they are the ones the judges see displaying the bad example, but what of the judges ourselves? We are a more important example than the lawyers. When as a litigating attorney, which is what I was when I wasn't being a judge during my professional years, I knew that in the trial court, the jurors were greatly affected by the commanding figure in the black robe who sat up higher than everyone else in the courtroom. It was evident that the trial judge was in charge. As I became a trial judge, I had the sense that other trial judges do, that I was captain of the ship. I was in charge. And it might at times have gone to my head or to the head of other judges, but it's nonetheless true. A person who is endowed not only with the powers of an office, but with the apparent trappings of that office, automatically sets the tone for those who appear before him, whether that be the lawyers, the witnesses, or the jurors. We often express the fear that judges may be unable to follow the jurors may be unable to follow a judge's instructions, but after a career of litigation, I'm thoroughly satisfied that they try. They may not always be able to, but I think they try. Jurors genuinely look up to the man or woman sitting higher than everyone else and issuing orders that everybody has to follow. They try to do what that person wants. If that person is uncivil, rude, or unkind to the attorneys and parties and witnesses, what response do we expect from the layperson sitting in the jury box? And it's not just the jurors. Understand that the ordinary citizen may read about the Supreme Court, but their personal understanding of the courts is generally gained from the trial court, particularly the state trial courts, which they may actually see in action. During my conspicuously long tenure as a judge of the United States Court of Appeals in Washington, I've been recognized by strangers outside the courtroom, outside the courthouse area, not the courtroom, but outside the courthouse area, perhaps a half a dozen times, when I was a trial judge in the lower tier of a two-tier trial court in North Carolina, every week or so somebody would call me judge that I didn't recognize. Sometimes he would tell me that he or she had been a juror, a witness, or God forbid, a party in my court. Then you got to think, now what did I do to them? At that trial level, indeed at every level, the judge is the conspicuous figure who sets the tone that the citizens discern as the proper behavior in the temples of justice and by extension in society as a whole. We do not always maintain the standards that we would expect in others. Sometimes judges are rude to attorneys, to witnesses, to parties, and to court personnel. The judge, being in the command position, has the power to humiliate, demean, and hamper the practice of those who appear before the court. Too many of us let our feelings toward lawyers or cases be visible in our demeanor and in our choice of words. It's tempting to fill the rest of my allotted time with horrible examples of judges failing to maintain the standards of civility which our position should demand. It would, I'm afraid, be easy to find plenty of examples. But for the sake of concreteness, I will offer a rather extreme example from an opinion of our court, United States versus Donato, 99 F. 3rd 426 and 435. We vacated a conviction and sent the case back for trial before a different judge, observing, quote, that the judge frequently berated, interrupted, and otherwise spoke negatively to the defendant's attorney. Indeed, we noted that, quoting again, during what were arguably the two most crucial moments of the trial for the defendant, that is, the cross-examination of a government's witness and the direct examination of Donato herself, the trial judge addressed approximately 65 negative comments to the defendant's attorney, 55 of which were made in the hearing of the jury. For more detail, you may research the case for yourselves. It's rare that an example of judicial incivility is so shocking and pervasive as the one before us in that case, and it's rare that the remedy has to be so extreme. But it is the extreme case that illustrates the dangers of the norm. I do not mean to pick on trial judges. Well, I do, but I mean to pick on appellate judges too while I'm at it. As I admitted at the beginning of these remarks, I have erred in the role as three different kinds of judge, and if charged with doing so, I'd have to plead no contest at least. But I've seen other appellate judges and heard of still others who have crossed the civility line and done so sometimes dramatically. We have browbeat counsel, and we have not always been civil to each other. One United States Circuit judge, not on my circuit, told a colleague to shut up during an en banc hearing. While we don't have jurors to witness what we're doing, the appellate judge's effect on the civil tone of the whole system can nonetheless be devastating. I do not think it would be a good use of your time or mine to further catalog examples. I've probably said enough about what can go wrong on the civility front for judges while offering little in the way of positive cures. As I said early in these remarks, much has been written about lawyer civility, incivility, less about judge civility and incivility. Perhaps it's true in part because the lawyers are unwilling to risk the ire of the judges who are most likely to recognize themselves in the criticism they might offer. But there are some thoughts available on what can be done about judicial civility. I'm picking just a few. The Seventh Circuit adopted a statement of the court's duty to lawyers. Now, at least 5 states, Alabama, Delaware, Hawaii, Florida, and Ohio, have some sort of judicial standards. I offer you the Seventh Circuit statement, Court's Duty to Lawyers, as a fair prototype, and you'll find similar things in those state judicial admonitions. Seventh Circuit says, 1, we will be courteous, respectful, and civil to lawyers, parties, and witnesses. We will maintain control of the proceedings, recognizing that judges have both the obligation and the authority to ensure that all litigation proceedings are conducted in a civil manner. Second, we will not employ hostile, demeaning, or humiliating words and opinions or in written or oral communications with lawyers, parties, or witnesses. Third, we will be punctual in convening all hearings, meetings, and conferences delayed. We will notify counsel if possible. 4, in scheduling all hearings, meetings, and conferences, we will be considerate of time schedules of lawyers, parties, and witnesses. 5, we will make all reasonable efforts to decide promptly all matters presented to us for decision. 6, we will give the issues in controversy deliberate, impartial, and studied analysis and consideration. 7, while endeavoring to resolve disputes efficiently, we will be considerate of the time constraints and pressures imposed on lawyers by the exigencies of litigation practice. 8, we recognize that a lawyer has a right and a duty to represent a cause fully and properly, and that a litigant has a right to a fair and impartial hearing. Within the practical limits of time, we will allow lawyers to present proper arguments and to make a complete and accurate record. 9, we will not impugn the integrity or professionalism of any lawyer on the basis of the, excuse me a second, I've turned 2 pages, of the clients whom or the causes which a lawyer represents. 10, we will do our best to ensure that court personnel act civilly toward lawyers, parties, and witnesses. 11, we will not adopt procedures that needlessly increase litigation expense. 12th and finally, we will bring to lawyers' attention uncivil conduct which we observe. I don't know that that exhausts the catalog of a judge's responsibilities of civility, but I think it gives a good example of the kind of judicial standards that we should impose upon ourselves in dealing with the lawyers, the public, with litigation, with personnel. Now, some of the state standards are more specific than the Seventh Circuit recitation, but in general, that's a pretty good reflection. We certainly should be courteous, respectful, and civil to everyone who appears in the court, everyone who deals with the court. We certainly should not be hostile, demeaning, or humiliating in opinions or written or oral communications. We certainly should not be hostile, demeaning, or humiliating in opinions or written or oral communications. That bears the most repetition, I think, of any of the standards set forth. It's the great place where judges can react like not the kind of people they would like to be. You're in a position where you can say what you want to, and sometimes what you want to say ought not to be said, at least not in that way. Here also I will point out that judges should observe the same respect for each other. Not only should we not tell each other to shut up, but in dissents addressing a majority and in majorities addressing a dissent, or opinions discussing the opinions or ruling of the judges of a lower court or an agency appealed from, we should set the same example of civility. We should not unnecessarily say that the district judge has grievously erred when it's quite sufficient to say that judge erred. We should remember at all times that the time of the attorneys and parties and witnesses is just as valuable, and jurors is just as valuable as our own. We should never forget that the lawyers have a duty to their client, and we should not interfere with their ability to perform that duty unnecessarily. And we certainly should not impugn the integrity or professionalism of the lawyer on the basis of the clients or the causes he advances. And as Dean Brown reminded us in his remarks, neither should the judges be demeaned on the basis of the opinions, the decisions which they've reached, be it in capital cases or in constitutional cases. I'm departing from my prayer remarks to recall a candidate for a high executive office in another state who ran against his opponent in part by saying that this man had done pro bono work on behalf of murderers. I did pro bono work on behalf of murderers. I didn't vote for the candidate who demeaned his opponent in that fashion. In any event, particularly would that be true with judges. In the performance of the duties of the bench to the bar, judges should remember that we are all one profession. Too often we put on the black robe and come down with the disease of robitis. We begin to think that we are inherently wiser and smarter as a bench than those in front of us are as a bar. But we are one profession. We as judges are one segment of the legal profession. The lawyers are the larger segment. We like to think that before we attain the robe, we have proved ourselves in the practice of the legal profession that those in front of us may not have. Among the things wrong with that approach are that some of them at the bar may be better students of the law than some of the judges at the bench. And even if that's not true, they are still practitioners of the same profession, subject to the same professional obligations and entitled to the same professional courtesy as the bench. That courtesy, I think, is the aspiration of the Seventh Circuit standard and the state parallels. In addition to those state and bar codes of conduct, there's an older and simpler source and perhaps a truer guide. And again, I said early on that I would repair to religion, even though this is a state institution. But again, the admonition I draw from in religion is not going to be about theology, and it's not unique to one religious tradition. Briefly put, live according to the golden rule. Jesus said, "Do unto others what you would have them do to you." It's Matthew 7:12, and that observation by Jesus was not a new concept. As he said himself, this sums up the law and the prophets. Around the same time as Jesus, Rabbi Hillel was asked by a pagan if the rabbi could teach him the entire Torah while he was standing on one foot, and that if he could, he would convert to Judaism. The rabbi replied, "What is hateful to you, do not do to your neighbor." That is the whole Torah, the rest is commentary. About 500 years earlier in China, Confucius had taught, "Do not do to others what you would not want others to do to you." If I were called upon to state the rules of civility for judges while standing on one foot, I could do no better than that. So in closing, I would admonish myself and my colleagues at the bench and at the bar, but at the bench especially, before you speak to an attorney, be prepared to answer the question, is that the way I would want to be spoken to if I were the lawyer? Before you admonish a witness, ask yourself, is that the way I would like to be addressed if I were the witness? Before you display incivility to a colleague, ask yourself the same question. Like Rabbi Hillel, I would say, that is the law and the prophets, and all the rest is commentary. Thank you very much. The question that I understand the dean to be asking is, I alluded to the practice of some appellate judges of referring demeaningly to the opinions of the courts that they are reviewing, and what can we do about it? Way back about the time, and maybe a little before the time I came on the D.C. Circuit, a custom used to prevail, which unfortunately it no longer does, but that the circuit and district judges would have breakfast at the judicial conference and discuss what was on their minds. And the district judges, I think, chose Gerhardt Gazelle to say, "Look, will you quit that?" And they actually had a long discussion about it, and we, I think, have stayed away from unnecessarily characterizing the opinions of the lower court. Now, that's one thing that can be done, is that these circuit judges, appellate judges, Supreme Court can make a concerted effort to be civil, and the district judges trial judges can find ways to communicate that to the circuit and the Supreme Court. The Supreme Court's very hard to communicate with, but especially to the circuits. Also, in the years that have gone by since then, some of us have made a concerted effort in all those intervening years. When we get an opinion, we circulate the opinions first to the members of the panel, then to the full court. Those of us who are paying attention to such things will come back with our comments before they're released. Say, "Look, on page 13, you say thus and so." I'll give an example because you won't know what the case is or who I'm talking about, since it never came out that way. But one of my colleagues had written an opinion where he described the conduct of a district judge as bizarre. Well, there were only two district judges, former district judges, serving on my circuit, and each of us came back and said, "Look, colleague, That's not only not bizarre, it's not even unusual. You may be reversing it, may be error, you may find it prejudicial, but you're going to open yourself up to the laughing stock if you call it bizarre. Well, that was a bizarre example, but it is the case that we can admonish our colleagues if we see something that they may even have unthinkingly, not deliberately, but even unthinkingly have said that is an uncivil reflection on the decision maker that we're reviewing, and I would include the agencies as well as the trial courts. But we can tell each other, cut that out. And I think, at least on our circuit, we've done a much better job of that over the last 25 years than was the case before that. Did that answer your question, Lonnie? Okay, the question concerns what role discipline can play in the case of the uncivil or otherwise misconduct committing judge. It's rather hard in the federal system, where we're protected from removal by the Constitution, to do much. We do have a judicial council in each circuit to which complaints can be addressed. The usual remedy, if there is one there, is either, of course, dismissal in most cases, but if there is a remedy, it's going to be either a private reprimand or a public reprimand. There have been a few cases where the judicial conference has, judicial council has actually directed the judge be taken off the calendar because he or she was behaving so badly in the courtroom that he thought it was reflecting enough on the court that they said, look, just stop that judge holding court. There's been a little litigation of whether we can do that. We think we can, but be that as it may, that's not something you would do very often. Now, those are appealable to a national committee and theoretically ultimately to the Judicial Conference U.S. We have at times had things that were so bad that we actually referred to the House of Representatives 2 or 3 times for impeachment. But in the state courts, sometimes there will be statutory or other means for the Judicial Review Board to do something more than simply slap the back of the hand and say naughty, naughty. Again, that's something that ought to be used most sparingly. It does not do anybody any good to drag the petty out into the public eye, even if the petty has been particularly nasty. I think that's better dealt with as informally as possible, so that if the reviewing body has a means of simply giving a private reprimand, admonition, I think that, or warning even, I think that probably is better than having it, the dirty laundry washed in public, unless it becomes necessary. Now, does it become necessary? Yeah, it does sometimes. Some judges cross the line. As I said, there have been even a couple of impeachments that those go beyond incivility. They're in wrong things. But I hope that answered your question, or at least addressed it. It may not have answered it, but at least addressed it. That question concerns what role judges should play in the discipline of lawyers. I think the first one, there are levels of lawyer discipline that involve simply open or at-bench admonition of a lawyer for conduct in the courtroom that don't require any more than that. Drawing that line may be hard, but there come times when you have to report the lawyer to whatever the disciplinary body of the bar is, and I think a lot of judges have an obligation to cooperate with, and indeed we're allowed to serve on those disciplinary bodies. We can see more of what the effect of the lawyer's misconduct is than anybody else can see, but typically I think just an admonition is the thing that you do for the simple incivility. Now, you remember Delaware, this has been rather widely reported, had a Texas lawyer who came up and made a complete jackass of himself in discovery proceedings. They barred him from ever coming back to Delaware as a lawyer again. I would have too. I mean, there are lines that when they get crossed, you have to take extreme action, and I didn't blame Delaware for saying, look, this man can never appear as an attorney at our bar again. We won't have any more pro hoc vici for him. He's done in Delaware. Sometimes you have to take the extreme, but I think in the simple case, the ordinary case, counsel, I don't want to have to be on this telephone every time you people are taking a deposition. You are professionals, behave like a professional, and then in open court if it has to be, and then eventually if it gets to be too bad, then you take formal action as they did in Delaware or by reporting to whatever bar committees. Did that address your question? Or? That's a very good question, and it's harder to answer than it is to conceive. The question concerns how do you go about bringing about consensus when you're chief judge, and does that differ from when you're a member of a panel? I'm going to start with non-judicial questions that you need consensus on. That is administrative matters, public relations, things other than the actual decision of a case. That's where Harry Edwards, who wrote the article in your material, was a real master. When Harry came on, our court was not as collegial as it needed to be. Harry made from the very start the decision that if he knew there was going to be a dispute on a subject and that he would be identified with one side or the other as a dispute, before the subject ever came up, he would go contact these colleagues and say, now look, Larry, I'm going to ask the court to do so-and-so. Do you have a problem with that? And he would talk it out with the potential troublemaker or adversary before we'd ever got to be aired even among the judges. So the chief needs to be alert to what issues are coming up and willing to be responsive to them. Now don't ever assume you can do this perfectly. As I said, we review the opinions of our court before they ever come out. When the draft comes out and it has something in it that is uncivil toward either a lower court judge or a colleague, as chief, I, before me Doug, and before him Harry, would contact that judge and try to get them to change the opinion to a more civil reading. Usually they would. I can't say they always would. So you will find things and opinions that I wish were not in there of a civil nature. Now, on the question of substantive law, of course, as you said, judges are fiercely independent, and in the opinions is expressing an opinion of law. Maybe, and this I did as chief judge, but I also did it as presiding when I was not chief, and even as a member of the panel, maybe you can get a narrower opinion. If the opinion is too sweeping, it may prompt a dissent that isn't necessary if you could make the opinion just answer the very question that's essential to the decision of the case. Sometimes judges, mea culpa, are tempted to write an essay on the law rather than simply answer the question before them. And if you can talk each other into, look, I can join your opinion if you'll take out that dicta about this other subject and just stay with the subject that we need you to decide this case, you can build a consensus that might not be apparent at first. We had a pretty hot election law en banc one time, and one of my former clerks called me to say, how in the hell did you get a unanimous opinion on that? I said, it was not without effort, my friend. It took a lot of trimming and narrowing to ever get it down to where we got unanimity, but we did. And so often you can get even consensus by not demanding too much. If you will restrict your own demands to what you really have to have. Ronald Reagan used to say, be careful how you turn down most of what you want. So stay with most of what you want instead of having to have all of what you want, and you may come closer to being able to achieve consensus. Does that address what you were seeking? The question arises, as I understand it, from the high school mock trials, but I think it would extend to a broader subject of public perception of the courts. I think a judge has a very clear obligation to be part of the betterment of the system. Now, one of the ways in which that can be done is by the outreach to the mock trials. There are annual mock trials in D.C. with high school students. If we do those and do those right, we can set an example and also usually make remarks after those about how the system should work and how we perceive that it does work as far as solving the community's problems through the rule of law rather than with violence and disorder. Now, as you say, we have demanding schedules. I've done very little of that high school work. I've done an awful lot of law school moot courts over the years. I'm doing far fewer now. Hugh and I were talking earlier about we don't like to travel anymore. You get past 70, it slows down your travel. But relations with the law schools is important too, but relations with the public is very important. I was reminded of this when Dean Brown said about he asked his daughter what the first thing was that came to her mind when she thought of judges said bias. One of my nieces took me for show and tell to third grade one time, and the questions that the kids asked me about judging were not necessarily the same ones that you would expect from anyone else. One kid asked me if I'd ever stepped on the tail of that black dress that judges wear. But one of them did ask me, how do it make you feel when you walk into the room and everybody stands up? And that actually is a pretty profound question, because we are the people who hold an office which entitles us to respect. And therefore, we are obligated to remember that it is the office that has to be respected. I'm going to repair again to Lonnie's story there and say that some years ago, over 30 years ago when I was a state judge actually, a friend who was a congressman introduced me to someone and said, Dave is a judge. He has the only title that still commands automatic respect. And I said, well, Howard, don't forget there's coach. But coaches in recent years have lost a lot of respect, and I hope judges haven't lost too awful much, that the first response is bias rather than stand up when they come in the room. Thank you very much.